The main reason that it's a very good idea for you to run a potential termination of your employee by an experienced employment attorney before you make that termination decision is because what matters much more when it comes to wrongful termination claims and lawsuits is not the real reason that you have in your mind for terminating that employee, but what that employee may end up being able to show to the court and to the jury, and what kind of evidence they can put together to make it look like they were terminated wrongfully. In other words, just because you think you have all the legitimate reasons in the world for firing that employee legally doesn't mean that that employee cannot come back and sue you and have a fairly strong case, even if it's not a perfect case. And to clarify this point, I would like to bring a very common example of a real life situation. Let's say you have an employee who reports to you and he has been with the company for 10, 15 or 20 years. Maybe his performance has not been perfect all these years, but he must have been doing something right if he's been around for that long. And then at some point you become unhappy with that employee's performance, with his attitude or whatnot. And then there comes a day and you decide to fire that employee, and in your mind you're firing them for their performance or for their attitude. But guess what? A month or two before that termination, that employee filed a workers' comp claim, or he informed HR of his disability and requested an accommodation, or he informed HR that he's about to have a baby and he might need some bonding time in the nearest future, or maybe he went to HR and complained about some kind of harassment or discrimination issue, or he brought to their attention some potential safety violation, and you don't know about that. Now, if that employee is being fired, and he goes to an attorney who represents employees and he shows them the story, hey, I've been working for a company for 10, 15 years, everything was fine, I filed a workers' comp claim, or I informed them of disability, or I asked for some kind of protected medical leave or family leave, or I complain about harassment, and a month later I'm being terminated for quote-unquote attitude or performance when I didn't have any serious performance issues. Now, although timing is often not enough, timing alone is not enough to prove a case, it's certainly a good starting point for many lawyers to scratch their head and ask themselves, there has to be more to the story, and I'll probably find out some emails and some documents that would support the case further and would show that at least one of the reasons for terminating that employee is whatever that protected activity that that employee engaged in. And regardless of whether you end up winning or losing a case, when you don't make sure that you don't have that situation where an employee engaged in some kind of protected activity before being terminated, you encourage a lawsuit against you, and whether you win or lose, you encourage this expense, which is often a significant expense. Now, the way to avoid this expense is to have a detailed consultation with an attorney to tell the whole story about why you're terminating that employee to the attorney, to have that attorney test that situation against potential lawsuits and make sure that that person will truly not have a case, or they're very unlikely to come back and sue you, because employment cases and employment situations are notoriously not black and white, and there's often a gray area. But the least you should do to minimize the risk, to minimize the exposure to litigation, is to run the termination by an attorney, because often an innocent situation can turn very ugly. Again, not because of what your real reasons for terminating that employee are, but because of all the other circumstances that maybe you were not aware of or you didn't think were important when making that firing decision. Thank you.